The 3 words that can save you thousands at a traffic stop. Know your rights before the red and blue lights. What would you say if a police officer walked up to your window and asked, "Where are you coming from tonight?" Most people think it's small talk. It isn't. That question is the first move in a legal chess game, and your answer could cost you your license, your money, or your freedom. The moment those lights come on, you're in an investigation, not a conversation. Every driver in America will be pulled over at some point. The difference between a warning and a warrant often comes down to what leaves your mouth in the first 60 seconds. You don't need a law degree to protect yourself. You need a plan, a script, and the confidence to use it. That's what this guide gives you today, right now, before you ever see a cruiser in your mirror. The value is simple. Stay legal, stay calm, stay free. You're legally required to hand over 3 things: license, registration, and proof of insurance. That's it. You are not required to explain your day, a destination, or your dinner. Police are allowed to ask questions because voluntary answers become evidence. Your silence cannot be used against you, but your words absolutely can. Knowing that difference is power. I'm Robert, and I learned this the hard way at 39. I was driving home through Escondido after a late shift when I got stopped for a broken taillight. The officer was polite. He asked, "Where are you headed?" I said, "Home from friend's birthday." Next question. "Any drinks tonight?" One honest answer turned into a 45-minute roadside test, a $10,000 DUI attorney, and 6 months of stress. I blew a 0.00, but the stop still derailed my life. If I'd known my rights, that night would have ended with a fix-it ticket. Here's what police training actually teaches. The traffic stop starts before the officer reaches your window. Questions like, "Where are you coming from?" and "Have you had anything to drink?" are investigative tools, not icebreakers. They serve 3 purposes. First, they buy time while the officer observes you for nervousness, slurred speech, or odors. Second, your answers can create reasonable suspicion to extend the stop. Third, under Wren versus United States, 1996, officers can use minor violations as a pretext to investigate other crimes. The conversation is the investigation. The law gives you clear boundaries. You must provide your driver's license, registration, and proof of insurance when asked. In some states, you must also verbally identify yourself. Beyond that, the Fifth Amendment protects your right to remain silent. You do not have to explain where you were, where you're going, or what you've been doing. You can decline to answer by saying, "Officer, I don't answer questions." You can also ask, "Am I being detained?" or "Am I free to go?" Silence is legal. Lying is not. That harmless question is designed to feel harmless. It's a consensual encounter that can flip to evidence in seconds. "I'm coming from my buddy's house" becomes "Were you drinking there?" which becomes "Step out for a field sobriety test." You walk yourself into it by being polite. Politeness is good. Volunteering details is not. The officer is allowed to ask. You are allowed to politely decline. So what do you actually say? You use a script. Scripts remove panic and keep you respectful. When the officer approaches, have your hands on the wheel. When they ask for documents, say, "Officer, here's my license, registration, and insurance." If you need to reach for the glove box, narrate it. "My registration is in the glove box. I'm reaching for it now, okay?" This prevents misunderstandings. Clear communication keeps everyone safe. When investigative questions start, switch to your rights. If they ask, "Where are you coming from?" you say, "Officer, I don't answer questions. Am I being detained?" or "Am I free to go?" It's short, polite, and firm. You are invoking the Fifth Amendment without being confrontational. You don't owe an explanation of your day. You owe compliance with lawful orders only. That's the line. If they push with, "Do you know why I pulled you over?" the answer is always, "No, sir/ma'am, I don't." Do not guess. Do not say, "I was going a little fast." That is an admission, and it will be in the report. Let the officer state the reason. If there is no legal reason, the stop itself can be challenged later. Your job is not to help them build a case. Your job is to get home. Search requests are next. "You mind if I take a look around?" is not a command. It's a request for consent. Your answer, "I don't consent to searches." Say it once, clearly, and then stop talking. If the officer has probable cause, They don't need your permission. If they don't, your refusal cannot be used against you. Never physically resist a search. If it's illegal, your attorney will fight it in court, not on the shoulder of the highway. Orders are different from requests. Under Pennsylvania versus Mims, you must step out of the car if ordered. Do it. Say, "I will step out, officer. I don't consent to any tests or searches." Field sobriety tests are voluntary in most states. You can refuse them. Breathalyzers are different post-arrest due to implied consent laws, but roadside tests are not mandatory. Refusing may lead to arrest, but so can performing poorly. Know your state law before you need it. If the worst happens and you're arrested, the script changes to 5 words. I want to remain silent. I want a lawyer. Then actually remain silent. Don't explain, don't argue, don't try to talk your way out. Every word after arrest is evidence. The time to fight is later with counsel in a courtroom. The side of the road is not where cases are won. Key rules will keep you out of trouble. First, be boring. No sudden moves, no attitude, no jokes about donuts. Use "yes, sir" and "no, sir." Officers are humans doing a dangerous job. Calm de-escalates and gets you home faster. Second, never lie. Silence is protected. Lying to police is a crime. If you can't answer, say you're exercising your right to remain silent. That's it. Recording is a powerful tool when it's legal. Most states allow you to record police in public as long as you don't interfere. Tell the officer, "Officer, I'm recording for both our safety," and keep the phone visible on your dash. Don't hide it and don't wave it around. A visible recording often improves behavior on both sides. Check your state's wiretap laws, because a few require two-party consent. Passengers have rights too. Unless the officer has reasonable suspicion that a passenger committed a crime, passengers don't have to show ID. Passengers can also remain silent. They should follow the same script. Polite, no answers to investigative questions, no consent to search. One person talking too much can create problems for everyone in the car. Ending the stop correctly matters. Once the officer has issued a ticket or warning and returns your documents, the legal basis for detention is over. If they keep chatting, ask, "Am I free to leave now?" If the answer is yes, leave calmly. If they say no, you are being detained and should continue to remain silent. Don't volunteer to hang out and answer more questions. The stop is over when you drive away. Here's what never to do. Don't argue roadside about the law or the ticket. The shoulder is not a courtroom. Don't touch the officer or reach without announcing it. Don't admit to just 2 beers or "I might have been speeding." Don't consent to a search because "I have nothing to hide." Innocent people consent to searches that find old mistakes, borrowed items, or things they didn't know were there. The Fourth Amendment exists for a reason. The bottom line is simple and repeatable. Comply with lawful orders and provide required documents. Don't volunteer information. Don't consent to searches. Ask, "Am I free to go?" This formula protects you without escalating. It respects the officer's job and your rights at the same time. You can be courteous and still be careful. Thousands of drivers think cooperating means confessing. It doesn't. Cooperation means following the law. The law says you must ID yourself and show papers. The law says you may remain silent. The law says you may refuse searches. Using those rights is not suspicious. It's smart. Judges expect citizens to know this. Juries expect it too. This isn't anti-police. It's pro-Constitution. Good officers appreciate a calm, informed citizen who makes the stop safe and quick. Bad stops get challenged later with data, not debate. Your phone video, your short answers, and your lack of consent create a clean record. That's how you win if it goes to court. You win by what you don't say. Practice the script before you need it. Say it out loud in your car. "Officer, I don't answer questions. Am I being detained?" or "Am I free to go?" It feels weird the first time. It feels normal the third time. In a stressful stop, you'll default to what you practiced. Muscle memory beats panic every time. Teach your kids the same words before they get a license. The Supreme Court has ruled repeatedly that pre-text stops are legal, but extended detention without reasonable suspicion is not. Rodriguez versus United States, 2015, said a stop can't be prolonged for a dog sniff without cause. Your question, am I free to go, forces the officer to state their legal basis. If they don't have one, the stop should end. That's your protection in real time. Night stops add risk for everyone. Keep your dome light on, hands on the wheel, and movement slow. Tell the officer what you're doing before you do it. My wallet is in my back pocket. I'm reaching for it now. This courtesy prevents tragedy. It also shows the camera and the court that you are compliant. Safety and rights work together, not against each other. DUI checkpoints are different. You must stop, show documents, and answer basic identifying questions. You do not have to answer, "Have you been drinking?" You can say, "Officer, I don't answer questions." You may be sent to secondary inspection. That's legal. Refusing roadside tests is still your right in most states. But implied consent laws apply post-arrest for chemical tests. Know your state's specific DUI law. Minors and new drivers face the same rules, but parents should role-play this at the kitchen table. A 16-year-old's instinct is to overshare. Replace that instinct with a script. The goal is not to beat a ticket. The goal is to avoid turning a ticket into a case. Every attorney will tell you, the best clients are the ones who said the least on the scene. If English isn't your first language, you still have these rights. You can say, "I do not speak English well. I want a lawyer." You do not have to guess at questions or sign documents you don't understand. Ask for an interpreter if you're detained. Courts provide them. The Constitution protects persons, not just citizens. That distinction matters on the roadside. After the stop, write down everything you remember: time, location, officer name, badge number, what was said. If you were recording, save the file in 2 places. If you got a ticket, read it carefully and show up or pay by the date. If your rights were violated, contact a civil rights or criminal defense attorney. Do not post the video with commentary accusing the officer of crimes. Let your lawyer speak for you. This knowledge isn't paranoia. It's preparation. Seatbelts don't mean you plan to crash. Knowing your rights doesn't mean you plan to break the law. It means you plan to get home. The officer wants to get home too. Clear scripts, calm voices, and clean records help both of you do that. That's the real win. Print this and keep in your glove box. Tape it to your visor. Share it with your family. The next time you see red and blue lights, your heart will still race, but your mouth will know what to do. 3 things: license, registration, insurance. 5 words. Am I free to go? Everything else is optional, and that option belongs to you. Traffic stops in the United States have evolved into structured investigative encounters where initial questions serve legal as well as safety purposes. Law enforcement training materials and court decisions confirm that inquiries such as, "Where are you coming from?" are used to assess driver behavior, detect impairment, and develop reasonable suspicion beyond the original traffic infraction. The Supreme Court's decision in Wren v. United States, 1996, upheld the legality of pretextual stops, allowing officers to stop motorists for minor violations while investigating other potential offenses. Consequently, a driver's voluntary statements during these early moments can become part of the evidentiary record used to justify prolonged detention, searches, or arrest. Constitutional protections define the limits of what a driver must disclose during a stop. The Fifth Amendment guarantees the right to remain silent, meaning individuals are not compelled to answer questions about their travel, activities, or alcohol consumption. The Fourth Amendment governs searches and seizures, requiring either consent, a warrant, or specific exceptions such as probable cause or officer safety. Pennsylvania v. Mims, 1977, established that officers may order drivers out of the vehicle during a lawful stop. Rodriguez v. United States, 2015, clarified that extending a stop beyond the time needed to address the traffic violation requires additional reasonable suspicion. State laws vary on identification requirements and implied consent statutes related to chemical testing. All states mandate that drivers produce a license, vehicle registration, and proof of insurance upon request. Some states have stop and identify statutes requiring a person to provide their name if lawfully detained, while others do not. Field sobriety tests are generally voluntary before arrest, whereas post-arrest blood or breath tests fall under implied consent laws with administrative penalties for refusal. Drivers benefit from knowing their specific state codes before an encounter occurs, as ignorance of the law does not excuse noncompliance. Practical communication strategies reduce the risk of escalation while preserving legal rights. Experts in criminal procedure and civil liberties organizations recommend keeping hands visible, announcing movements before reaching for documents, and using concise, polite phrases. The recommended response to investigative questions is, "Officer, I don't answer questions. Am I being detained?" or "Am I free to go?" This asserts Fifth Amendment rights without being confrontational. To refuse a search, the phrase, "I don't consent to searches," is legally sufficient. Physical resistance is never advised, as unlawful searches are challenged in court rather than on the roadside. Recording police interactions is permitted in public spaces under the First Amendment, subject to state wiretap laws. The majority of states allow one-party consent for audio recording, enabling a driver to film the encounter provided they do not interfere with the officer's duties. Clearly stating, "Officer, I'm recording for both our safety," and placing the device on the dashboard can increase transparency and accountability. Legal analysts note that video evidence often improves conduct and provides an objective record if a stop is later contested. Passengers are subject to the same constitutional protections, but have fewer obligations. Unless an officer develops reasonable suspicion that a passenger has committed a crime, passengers are not required to provide identification. They may remain silent and may refuse consent to search their personal belongings. However, officers may order passengers out of the vehicle for safety reasons under Maryland v. Wilson, 1997. Passengers should avoid sudden movements and should also use clear language to invoke rights. The conclusion of a traffic stop is legally significant. Once the officer has completed the mission of the stop, such as issuing a warning or citation, and returns the driver's documents, continued questioning without additional reasonable suspicion constitutes a new detention. Asking, "Am I free to leave now?" requires the officer to either articulate a basis for further detention or allow the driver to depart. Remaining at the scene voluntarily to answer more questions can convert a completed stop into a consensual encounter, during which further incriminating statements may be gathered. Documentation after the fact strengthens any future legal claim. Attorneys advise writing down the date, time, location, officer names, badge numbers, and a narrative of the events as soon as possible. Preserving dashcam or phone video in multiple locations prevents loss of evidence. Fighting a citation or challenging a search is done through the court system, not at the scene. Consulting a qualified criminal defense or civil rights attorney ensures that procedural violations are properly raised and that constitutional protections are enforced. Understanding these principles benefits both motorists and law enforcement by promoting predictable, de-escalated interactions. Compliance with lawful orders, combined with a clear invocation of rights, reduces ambiguity and potential conflict. Public education on traffic stop rights aligns with broader efforts to enhance community trust and procedural justice. While statutes and case law continue to evolve, the core framework of required documents, optional conversation, and consent remains the foundation of roadside interactions.